One matter which was listed yesterday before Honorable Justice Sundi Nair. That's the election matter. My learned friend Mr. Tiwari Pavan was with me, but he could not take up the matter because he was the counsel. So only I just mentioning it because the election matter. So can it be fixed on 13, my lord? My learned friend is here. I requested my learned friend. That's why because I don't know, he is not fixing the date. He can't fix the date because he was the counsel there.
But then another difficulty, 13th I may agree for his sake, but not, but then another matter, then possibly if today's matter, if it is not concluded today, then my esteemed colleague will make a similar request that today's matter also be taken up on 13th.
Okay, it's okay, fine. No, that's I will adjust. He adjusted. I know I requested it. He adjusted. No, we will adjust. There is no problem. Absolutely no problem. No problem. No problem. Deeply obvious.
Your Lordship, I'd like to mention item number 4, Your Lordship. My Lord, I'm appearing on behalf of the petitioner. My Lord, in this, we have to file our affidavit in reply.
Both sides are represented on the prayer made by counsel for the petitioner. List after
3 weeks, Your Lordship.
3 weeks, reasonable to file affidavit in
Reply.
reply. Okay.
Obliged, Your Lordship.
May I plead your lordship? Madam, I like to mention item number 13, my lord. Here, my lord, our affidavit is ready. I'll be filing within a week, my lord. 13, my lord.
Okay. How much time?
2 weeks, my lord.
Okay.
My Lord, in item number 13, there's an interim order. It may be continued.
Okay. Both sides are represented on the prayer made by the government advocate. List after 2 weeks to reasonable to file affidavit in opposition in the matter. Next, interim order passed earlier stands extended to the next date of listing.
Obliged.
May I please your lordship? Lordship, item number 12, we have not still yet got the instruction. So another 3 weeks may be given.
You have informed the other side.
Lordship,
You have taken consent of the other side.
lordship,
Okay. With consent of the other side, Mr. I. Ram, the government advocate, prays for and is granted 2 weeks' time to file affidavit in opposition in the matter. Any interim order is there?
no interim order.
Okay.
Yes,
Okay. Yes.
My lord, may I
Please
mention?
button up your coat first. Button up your coat. Coat.
sorry.
Oblige, my
Yes.
lord, may I mention item number 5, 6, 7, 8, 9, my lord.
Okay. You're for?
5 to 9, my lord. My lord, I am petitioner, my lord. My lord,
Your
my senior
petition.
is I have taken consent from the respondent, my lord. And my senior is also in medical issues, my lord.
With consent of the respondents, the counsel for the petitioner prays for adjournment. So prayer is allowed. List after 2 weeks.
My lord, maybe fix on 4, my lord, for June, my lord.
No, not on 4th, 5th,
My lord,
5th June.
my lord. There's interim order that may be continued, my lord.
Interim order passed to this transaction.
May Lord kindly fix the matter on 4th.
4th is a hearing day. No, for that you have to make a request to the honorable judge. Who will be there because I'll fix it on a non-hearing day. If you want, I can already say next week you make a prayer before the honorable judge. Okay, don't say anything. List in the next week.
After a week, my lord.
After a week, okay.
My lord, may I mention item number 15, my lord. I have taken consent from the respondent, my lord.
15 is a order matter. Why it has come for orders?
We have to file our affidavit, my lord. We have yet to receive instruction, my lord.
But it's a 23 matter.
Yes, my lord.
Which
Last time will
department?
be given, my lord.
Which department?
Yes, my lord.
Which department?
Department, my lord, is land, my lord.
Land management.
Land department. And DC is young, my lord.
Okay, 15. On the prayer made by the government advocate. List after,
My lord, 1 week, my lord. 1 week, my
2
lord.
weeks, my
she
lord.
wants to file
2 weeks, my lord.
2 weeks. Next, the learned government advocate shall send a download copy to the respondent authorities to keep them informed that this is the last chance to file their affidavit in opposition in the matter. Failing which the matter would be heard on the basis of materials available on record. List after 2 weeks.
My lord. Item number 17, my lord. I'm here, my lord, respondent, my lord.
Item,
17, my lord.
yes,
My lord, this matter also may be released after.
you've taken consent?
Yes, my lord.
So,
On
consider
5th,
the
my lord, if possible, my lord.
petitioner pays for a, sorry, respondent pays for adjournment, there is allowed. List on 5, 6. Okay.
Oh, nice.
My lord, here we are yet to receive instructions, my lord.
Okay. Is Mr. Moore here? No,
Sir Mao.
Moore, he's not there. Okay.
Why the matter has come up for motion again, my lord?
No, because notice of motion was not issued, I
Yeah.
think.
Yes, it's.
We issue notice, otherwise it becomes
Yes, ma'am.
difficult to dispose of in the motion stage. But Mr. D, funding and counsel for the petitioner, as well as Mr. N. Ratan Ramesh, additional advocate general for the state respondents. Next one. By order dated 12/3/2024 and 23/4/2024, the matter was adjourned so as to enable the departmental counsel to produce instructions as to in what manner conclusion was arrived at that the rates quoted by the petitioner and the respondent number 6 firm was decided to be abnormal in nature. First of all,
Mao, Sunil Mao.
although first of all, therefore, the court is entitled to issue notice of motion returnable in 4 weeks. Requisite extra copies of the petition be served on the government. Additional advocate general in respect of respondent numbers 1 to 5. Next, the petitioner shall take steps for service of notice on respondent number 6 by registered post with AD, which is made. Take steps within 2 days for service of notice on respondent by registered AD, which is made returnable. Or give a fixed date after 4 weeks. Return also and so. Next, the learned counsel for the petitioner is granted liberty to collect the postal receipt number from the registry and submit postal track report prior to the next date of listing. Next, the interim order passed on 12/3/2024, directing that the financial bids of the bidders in pursuance to the NIT dated 4/3/2024, shall not be opened without the leave of the court, or stands extended till the next date of listing. Next, the learned additional advocate general shall transmit a downloaded copy of the order passed today to the concerned respondent authorities.
This one.
So before that, you write. It is made clear that as the court is awaiting instructions since
12-3.
order dated 12/3/2024. If no affidavit in opposition is filed by the respondents, the court would be inclined to invoke the doctrine on non-traverse and presume that there was gross illegality in the action of the respondents, and matter would be heard on the basis of materials available on the court.
Obliged. Mr. Mao is here.
Yes, Mr. Mao.
Yes.
I had to call you. I have checked up. We permit you to withdraw it
Okay.
without any observation. Without any observation. of the court.
Observation.
Okay.
Obliged.
Just write an order. It was yesterday's matter, item number. That was yesterday, item number.
Item number 3, I think, Malar. I don't have that list.
Item 4. That's item 4. Yesterday's matter. Mr. Mo, I'm just asking you because at times the clients of yours may not be happy. May I just add 2 lines there that after some deliberations you wanted to withdraw it, or should I say nothing? But I mention in the order that after some deliberations you wanted to withdraw it,
Yes, maybe
or
that.
should I not say anything?
Or maybe fixed next date, my lord, so that I can satisfy with some judgments, my lord. I'm told there's some judgments that it can, I can research on and I can place that judgment. Next maybe
But Mr. Ismail, the counsel for the
after 2 weeks, it may be fixed in
And-
2 weeks.
Ms. R. Basad, the government advocate, appearing for the respondents. Next one. The learned counsel for the petitioner shall address the court as to whether repetitive writs is permissible when no steps was taken for enforcement of the order passed in the previous writ petition. The learned counsel for the petitioner prays for some time to address the court. List after 2 weeks as paid for. Okay.
Obliged.
Number 9.
My esteemed colleague, Mr. Divanko Das insisted a lot. Otherwise, I wanted to leave yesterday itself. Now, in this case, beloved, let me just give a background. What the matter is all about. There are multiple interlocutory applications. So first of all, beloved, those interlocutory applications filed by us, the NHPC, and which have become infructuous with the passage of time, I will close them. So I'll just point out what those interlocutory applications are.
Let him come again. We have to read it. Just 2 minutes.
In the meantime, I explain, my lord, what it is all about. Otherwise, or else my lord may take up other cases. Very good.
He'll be aggrieved. He will not know.
He may not be aggrieved. By IAs at least, the one I am closing, he should only be happy.
Yes. You're right. You're right. We were inclined to close on that day, but
Naturally, the day when I wanted to close. Those IAs had relevance at that stage. They no longer have any relevance now because circumstances have changed.
Item number 11.
Well,
My lord, we have filed our respective affidavits. my lord.
Yes. I didn't get it. Please repeat again.
We have filed our affidavits, my lord.
You filed.
Yes, my lord.
Okay.
The state has also filed, my lord, and I'm appealing for respondent number 6, my lord.
Okay. It is available.
Yes, ma'am.
Yes.
Well, we had respondents also already filed the affidavit, so I'll pray for the disposal. Well, the basic case, my lord, here is the, of the petitioners is that in violation of the guidelines, just to favor the private respondent, even though the guidelines says that when there is a single tender, there should be it should be a fresh tender should be issued. But in spite of that, the respondent authorities, they have decided to go ahead with the tender process and award the work to the private respondent. My lord, this NIT, my lord, is said,
But you see, the stand of the respondents,
my lord,
I won't remember whose affidavit I saw. But they've taken a stand that when these bids were open, you did not lodge any protest.
my lord.
And therefore, subsequently, the technical bids were evaluated and then the financial bids were opened.
My lord.
Yes. So
Yes,
if you have not made a complaint then,
No, my lord,
Is it
since
too
here already out of 6, 5 had been rejected. Already out of the 6 bidders, man, already 5 bidders, they were declared non-responsive in the technical evaluation. So automatically there would be a fresh tender.
No.
That is the
I don't read that. Because you see, you are relying on page 54 clause 5.8 about the single bidder. It's not a single bid received. It is 6 bids received, 5 were
Yes.
held to be disqualified. You are basically relying on page 54
yes, man.
clause 5.8 to show that if there's only one bidder, it will be rejected.
My lord.
But it appears from your own statement and the materials available on record that there were 6 bids submitted. Out of 6 bids, 5 were rejected
Yes, ma'am.
and as technically non-responsive.
My lord.
So therefore, this is not a case where there was only a single bid.
No, my lord, if your lordship would see, my lord, the definition of a single tender, man. If after the technical evaluation also,
Is there any pronouncement as to if rejection on 5 bids, only one bid remains, it is a single tender?
my lord, these guidelines, it's very clear, my lord. Definition of single tender, my lord, 5.8A, my lord.
I've read that,
Yes,
that's why I'm asking you.
Yes, my lord. If consequent to invitation of tenders bids for any package, only one bid tender is received.
So this is not a case of one bid received. This
No,
is a
sir.
case of 6 bid received, but 5 were non-responsive.
My lord,
Now let us say if there was 100 bids,
my lord,
again 99 were rejected,
My
then
lord.
what you would say?
my lord, that will still, as per the definition here in my lord, it would,
Can't agree.
my lord will see, my lord. Single bid is received or consequent to technical evaluation, if only one bid tender is found substantially responsive, such bids tender shall be termed a single tender for the purpose of the PMJ as well. So after the technical evaluation, my lord, because my lord, here the purpose here is that, my lord, so that the transparency and fairness is maintained, my lord. Because it might happen that the authorities, my lord, if they are hand in glove with the one party, my lord, they might reject 99, my lord, and only one will be technically responsive, my lord. So that's why, my lord, it has been said, my lord, it has been clearly mentioned that even if after the technical bid also, only one bidder is substantially responsive, it would also be a single tender. Because there was lots of ambiguity, and after this guidelines was issued after taking suggestions and from all the states, man. Because there might have been cases.
What you call? When did you enter into agreement with the other party? With the respondent number
Agreement in terms
6?
29
20?
February 24.
What is the date of technical rejection?
18, my lord. 18/1/24.
Where is the comparative statement?
Comparative statement is, it starts at my lord, page, 30, my lord. Page 30, my lord.
30.
30. Mama, what happens, my lord? After I have been declared in non-responsive, my lord, I cannot further see the progress in the, my lord, portal. Now they have taken a stand that there is delay, that I have approached late, my lord. But after I have been declared responsive, technically non-responsive, I cannot log into it anymore. And my lord, I have a specific,
Okay,
my lord.
we'll come to it just a moment. No, but you see, this page 30
30.
is a document you have enclosed in your petition.
Yes, ma'am.
That means at least this document till this time would have been accessed by you.
Yes, this was, my lord.
Correct.
Yes, ma'am.
So therefore, this shows that they were, except for one, everybody else was non-responsive.
My-
Non-responsive.
My lord.
But you allowed this agreement to happen.
No, my lord, my lord, I have made a specific pleading, my lord, starting from paragraph 8. My lord, since we received this in the email, my lord, we had access to this document, my lord, the technical evaluation, my lord. After that, we approached the department, my lord. They said because it's a single tender as per the guidelines, we have said in paragraph 8 onwards, my lord. So they said they will look into it. Then they assured us. And in response to this, they have not even denied these statements, my lord. The respondent authorities, my lord. They did not comment on this aspect. We have specifically made that we approached the department because there is a after the finding they said that we will open the financial bid. So accordingly we approached the department. Since there is it's a single bid, there should be retender. So we were given assurance, man. And that we have said in our pleadings starting from paragraph 8, my lord. And in response to those our pleadings, my lord, the state department has said nothing, my lord. Meaning thereby that they admitted that they issued, man. So we are under the impression that it will go on, but only when we continuously approach the demand, then only we came to know that the technical financial evaluation has been made, and then though it was the private respondent has been recommended, my lord. We were kept totally in dark, my lord. Only assurances were given that we will look into it and then retender would be made. That we have specifically said in our pleadings, my lord, paragraph 8 onwards, my lord, which they have not denied me. So we are always under the impression, my lord. So behind our back, they went on with the went ahead with the technical financial evaluation, and even in the financial evaluation also, they come to a finding that it is seriously unbalanced. But even then, they went ahead and entered into the agreement.
Yes, Mr. Tarak.
Para 5
Para 5
of my reply. That we have specifically mentioned that regard this statement para 8 to the
8 to 10 of the writ petition answering the pornography status, section 22.6 of the standard living documents. And then it provides that the result of the examination of part 1 of it shall be made public on e-procurement system, following which there will be 5 working days. During that 5 days, he have to lodge a complaint if there is any issues or problem.
Which page is 22.6?
Page 3, 22.6 is my annexure. Annexure A, page 10 of my affidavit.
Annexure A, page 10.
SPD 2 page. So till signing of contract agreement.
Mr. Tarak, you see, when your clause says that if it is one tender, what is PM gave in this scheme, when there is one tender, even if 6 people participate, and there's only one final tender remaining in technical evaluation, it will be considered a single tender. So question of objection is not even required.
Why not? That's
Your-
what
It's against your tender, what do you call,
the reason is given, that is. Page 30.
in the advertisement was it there, that single tender is not, will not be followed?
No, why they have? it's
No,
a
no, why
recommend
they
for-
have done it is different.
Since the period of the work is 12 months. So they have to give reasons.
Once it is illegal, it is illegal. It has to be set aside.
Otherwise, my,
You did not inform the public, you did not take, have you taken, what do you call this, administrative approval from the concerned secretary? That you will be violating this tender clause?
the same has been recorded to the authority, higher authority. Financial bid has to be approved by the chief engineer.
Financial bid is something else. This is your tender document. Your tender clause says it is one bid. It has to be one bid. Now you show that you have taken approval, administrative approval prior to the issuance of the, prior to the technical evaluation, that you will not be adhering to this clause. A document must be pre-dated, not post-dated.
My lord, that, to that aspect, I agree, but now at this stage,
No,
Since-
whatever be the stage, it has to go.
since the
Illegality can be,
private husband already started the works, so it's public interest also involves.
they will,
Public needs
you will suffer for that.
road.
We'll ask it to be recovered from the salary of your officers who are involved in the technical evaluation.
But sometimes for interest of the public, they have to,
No, public has no interest.
Otherwise, my lord,
otherwise only bridge has to be constructed, road is on towards the
No.
completion.
We'll ask them to, any cost incurred by the department has to be recovered from them, from their salary after drawing up due disciplinary proceedings. Officers who have done that will suffer. You see, apart from public interest and all, under 226, this court is also a court of equity. How can we approve illegality on the face of record? It can't be done. Yes, what do you say?
Let it go, Colloquial. My lord, here. May I please, my lord? My lord, the NIT was plotted in 2011, my lord, November 2023, my lord. Thereafter, my lord, the work order to me was issued on 29 September 2024, my lord. And now, as for the NIT, my lord, the work is supposed to be, it is the construction of bridge, my lord, which is of immense public interest, my lord. And my lord, and the period for completion of that construction work is 12 months, my lord. Now, already 5 months have passed, my lord. Now, I have been issued the work order, the acceptance letters have been given, and I was in fact asked to pay additional security, my lord, which I have already paid, my lord. Now, I have already moved my machineries, the work is in progress, 50 to 20% of the work is completed, my lord. Now, even if, in the present situation, my lord, when new tender is called for, my lord, it will be a loss to the state executive, my lord. Because the cost of the project will increase, my lord, many folds, my lord.
No, we'll ask for recovery from the officers concerned. They will suffer for it. We'll just put them to notice that why they should not be asked. They should not suffer an order of a recovery being made from them. We'll put these officers to notice. This has to be quashed. And yes, Mrs. Okay,
Well,
why we should not invoke the principles of NG projects and say that if there is even a illegality, you will have a right to close this report for damages.
my lord,
Once the projects have started.
NG projects, my lord, subsequent to that also, my lord, the same bench, my lord, when in the Bombay High Court, my lord, they dismissed a writ petition, my lord. In the light of the principles of the NG projects, perpetuating the illegality, my lord. But although nothing much has been said in the judgment, that order, my lord, by the same bench, my lord, but they said that the NG project has been not taken in the right perspective, my lord. That, my lord. It's the same bench of the Justice M.N. Gupta and Subramaniam. They also
This Jai Bhagwan will not apply.
my lord.
This Jai Bhagwan will not apply. Because at the time, in this Jai Bhagwan case, the facts are very simple.
My lord.
That the respondent therein
My lord.
was disqualified at the time of the tender evaluation.
My lord.
And then subsequently his bid was accepted.
My
It
lord,
could
but-
not have been done once it is there. Here, that is not the case. Here is the case where there is an illegality in the
Yes, my-
process of tender.
Well, they are also that
No, but he was
underlying the
successful. Mr.
principle.
Para was successful.
Successful, my lord, but that
So therefore, they have run illegality. You have
That is
for
all-
recovery of compensation.
but the manner in which, my lord, the illegality has been perpetuated, my lord. I'm just, my lord, on one on the I could not give the list of books, my lord. This Patel Engineering,
Okay.
my lord, I will just read one paragraph. My lord. Paragraph, my lord, 24, my lord. I had marked it for myself, my lord. Here it has been said, my lord, that adherence to the rules, my lord, it is for a purpose only. My lord. Adherence to the rules or ITV, my lord. The guidelines, that is in fact in the public interest, my lord. Here is not a case where such relaxation could also be given for
going ahead with opening the financial bid of a single tender, my lord. When there is a certain set of guidelines, it's for the purpose of, my lord, to ensure the better works only. So the best adherence to ITV or the rules is the best principle to be followed, which is also in the best public interest. Now they have said that we have not lost any company, but there's no necessity for that because we were under the belief that fresh tender would be issued. And the pleadings that we have made, they have not even denied this, that they have not issued us in their affidavit, the respondent authorities. And as for my instruction, till that no substantial amount of work has been done. Only one pit has been dug. Other than that, no substantial work. They went ahead with the tender process by keeping us in dark.
After your rejection, you don't have a right to be informed. The respondents have no duty to inform you what they are going to do.
No, my lord, that's why, my lord. Now, of course, after the technical evaluation, that's why we have made the pleading, my lord, that we
That's
approach
okay.
them. Yes,
No, you did not file a
Yes.
complaint. You just said and they have not responded. But
yes,
the
we have
fact is-
approached them, my lord. They assured us, in fact, that is our specific pleading, my lord.
Assurance, that means you file a civil suit, recover it from that money, that person who has given you false assurance.
Otherwise, if this is allowed, your honor, my lord, they will continue to perpetuate this illegality in the name of public interest, that there was urgency as such. Once this is allowed, my the guidelines and the rules, it is there for a purpose, my lord, for ensuring transparency only, my lord, and to maintain fairness. Otherwise, under the garb of urgency, my lord, they will continue to do this and pick up just one person, reject everybody in a technical evaluation, my lord.
But Mr. T. Sokira will answer for the petitioner. Mr.
Gita.
G. Tarak Leonard, standing counsel for the RWD, representing respondent numbers 1 to 5. And Mr. O. Padar Leonard, counsel appearing for respondent number 6. By filing this writ petition under Article 226 of the Constitution of India,
May I please, my lord? My lord, I'll just take leave, my lord.
yes, the petitioner has prayed for quashing of the where is that minutes? Where is the minutes you want to quash?
Pale village. Pale over
Page?
date. Page 24, my lord.
24.
24 is the, my lord, e-notice, my lord, e-procurement.
No.
My lord.
Your prayer number 1 is for quashing of the minutes of financial evaluation. Where is that?
Prayer number 1, my lord. This is, my lord, financial evaluation, my lord, you said, page 34, my lord. I'm sorry, my lord, your lordship is not very audible.
The is paid for quashing of the bid evaluation report of part 2 of the bid. Dated 25/1/2024 by the bid evaluation committee of Arunachal Roads, Rural Roads Development Agency under Rural Works Department, Itanagar, whereby the bid of the respondent number 6 with a price bid of rupees 1, 49, 99, 557.22 against estimated cost of rupees 1, 76, 87, 000, which is below 15.19%, was declared to be L1 bidder, L1 bid. With consequent prayer to direct the respondents to forbear from giving effect to the said financial evaluation. With further direction upon the respondent authorities. With further prayer for a direction upon the respondent authorities to invite fresh NIT in terms of guidelines dated 7/5/2013. Next paragraph. The petitioner is relying on the guidelines for evaluation of bids and awards of contract under PMGSY scheme, specifically guideline number 5.8 within bracket A thereof, which defines inverted commas single tender bracket closed, comma inter alia, comma providing that if only one bid of the tender is received or consequent to technical evaluation, if only one bid of the tender is found substantially responsive, comma such bids of the tender shall be termed as single tender for the purposes of the PMGSY and if there is full stop. Under clause 5.8 within bracket B thereof, comma, there's a prohibition from opening a single bid public tender and the requirement is that the bids shall be re-invited. Full stop. It is the next part, it is not in dispute. Rather, it is admitted by the Rural Works Department in their affidavit in opposition filed on 30/5/2024 that out of 6 bids received, 5 bids were found non-responsive. And there was a single bid of the respondent number 6. Is that single bid document that your comparative statement? Where is that? Oh, page 31. It's 30. First one. The petitioner has annexed the bid evaluation report dash part 1 as annexure 4 to the petition, which discloses that which discloses the same fact. First stop. Therefore, it expressly appears that the acceptance of bid of the respondent number 6 by the competent authority under the Rural Works Department was illegal and violative of clause 5.8 within bracket A and 5.8.B of the guidance for evaluation of bids and award of contract under PMGSY scheme as contained in the circular under file number P-17025/33/P-Roman 3/NRRDA dated 7/5/2013, issued by the Government of India, Ministry of Rural Development. having held that the acceptance of bid of the respondent number 6 was in illegal exercise of power by the concerned respondent authorities, comma, the question required to be dealt by the court is as to what relief can be granted to the petitioner. Full stop. Case in hand. The technical evaluation of bid was done on 25. No, this is what is the date of this technical evaluation? Page 30.
It was published on 18/1, opened in November, my lord.
18/1/2024.
Opening was on 28/11/23. And
No, this document is page 30 is what date?
yes, this was published on 18/1.
18/1. Full stop. As per the contents of the bid evaluation report dash part 1 within bracket annexure 4, comma, the respondents had put to notice, all consent to notice that the financial bid would be opened at the office of the chief engineer, comma, RWD, Itanagar on 25/1/2024. Full stop. Consequent to the same, comma, the respondent authorities by a letter dated 17/12/2024, the executive engineer said, the executive engineer of the DIPU, comma, RWD, Likabali, by a letter dated 17/2/2024, issued a letter of acceptance to the respondent number 6 and in the affidavit in opposition filed by respondent numbers 1 to 5, it is disclosed that a contract agreement dated 29/2/2024 has been executed between the petitioner and the respondent number 6, and that the work of construction of RCC bridge over DIPA river at chainage 5730.00 M has started. So this writ petition was thereafter filed on 6/3/2024. Stop. We take note of the next paragraph. We take note of the decision of the Supreme Court of India in the case of N full stop G full stop Projects Limited versus Vinod Kumar G. This is Messrs. MS. M capital small s then full stop. M only S then full stop. NG Projects Limited versus Messrs. Vinod Kumar, Kumar Jain and others. Within bracket 2022, bracket was 6 SCC 127, comma, amongst others, comma, has held that the courts must not interfere where interference would cause unnecessary loss to the public exchequer. And it was further held that if the court finds that there is total arbitrariness or that the tender has been granted in a modified manner, still the constitutional courts should refrain from interfering in grant of tender, but instead relegate parties to seek damages for wrongful exclusion rather than to injunct the execution of contract. Next paragraph. The learned counsel for the petitioner has placed reliance on the case of Jai Bholenath, EHOLENATH, construction versus the Chief Executive Officer, Zilla, ZILLA, Zilla Parishad, Nanded, NANDED, and others. Order dated 18/5/2022, passed by the Supreme Court of India in Civil Appeal number 4140 of 2022, arising out of SLP within bracket C, number 7150 of 2022. This is the copy. Wherein the same bench which had authored the decision in the case of NG Projects Limited within bracket Supra had interfered with the tendering process and directed the Zilla Parishad to process the matter further from the stage prior to the issuance of corrigendum dated 24/11/2021. Next, we peruse this head. The copy of this judgment is produced by the learned counsel for the petitioner. From the contents of the said order, we do not, it cannot be deciphered as to whether the contract agreement was entered between the executing agency and the successful bidder. We gather from the said order that the acceptance of the bid of respondent number 4 therein was an action challenged in the writ petition filed by the appellant. And as the bid of the respondent number 4 was found to have been when at the time of opening of the technical bids, the said respondent was disqualified, the said order was passed. Next, in the present case in hand, the bid evaluation was purportedly done on 18/1/2024. And therefore, by the time this repetition was filed on 6/3/2024, respondent number 6 and the Rural Works Department had already executed an agreement dated 29/2/2024, and the work of construction of bridge has commenced. Full stop. It cannot be said that the construction of a bridge under PMGSY scheme is not a project which would benefit the public. Full stop. Under such circumstances, in view of the delay in approaching the court, the court is not to interfere with the tendering process. Next paragraph. The learned counsel, the petitioner, has strenuously submitted by referring to statement made in paragraph 9 of the writ petition that the petitioner did approach the executive engineer concerned, and he was informed that the matter would be looked into. And that after proper consultation, paragraph 8 and 9, and that after proper consideration, fresh tender would be invited. And thereafter, the representative of the petitioner approached the said office on 2 occasions, but could not meet the executive engineer. Yes, petitioner. In this context, it is pointed out, affidavit filed by the respondent numbers 1 to 5, the statement of the petitioners has not been denied, and therefore it amounts to admission. Therefore, in view of the non-denial of the statement made in paragraph 9 of the writ petition, the only conclusion that the court can draw is to invoke the doctrine of norms, and that the said statement of the petitioner that he had approached the executive PI Public Rural Works Department, within bracket respondent number 5, who gave the petitioners an assurance that the proper consideration fresh tender would be invited. The court is of the considered opinion that ends of justice would be met to relegate the petitioner to approach the civil court for claiming compensation from the respondents, state respondents, Therefore, the writ petition stands allowed to the limited extent of declaring that the action of the respondents, the respondent of the 3 to be evaluation despite there being a single bit remaining after technical and oppose the civil for claiming compensation. Next part. For the illegality committed as indicated above. The court is inclined to impose a cost of rupees 20,000 on the respondent numbers 1 to 5 to be paid to the petitioner with liberty to the government of Arunachal Pradesh. All the same. After due inquiry from the respondent number. Next paragraph, we government in the Rural Works Department is expected to issue reminder to all concerned to strictly adhere to the PMGSY guidelines henceforth. This you may take it after some time. Please take after some time. Returning your book. Watch it. Just one more paragraph. Yeah. You read which paragraph? I forgot this. Paragraph 24. Paragraph 24. It's very cited the judgment. The concept of the petition is also relied. So WB State Electricity Board versus Patel Engineering Company Limited and others within bracket 2001 brackets close to SCC 451 within brackets paragraph 24. To make home the point that the respondent authorities could not have given a go by to the rules or conditions of the bid under PMGSY scheme. And to bring home the point that if the rules are flouted, comma, the rule of law would be a casualty. And such flouting would impair the rule of transparency and fairness and provide room for manipulation to suit the whims of the state agencies in picking and choosing a bidder for awarding contracts. Stop. Under the circumstances related in this order, comma, the said observation made by the Supreme Court of India squarely applies to the facts of this case. Because the tender of the respondent number 6 was accepted by the respondent number 5 by flouting the guidelines. Referred above.
My lord, in this case, the writ petition is filed by NHPC. Punishment of the award because the land in this case, my lord, was acquired under section 10 of the June Land Regulation of 1947. Petition challenging the legality of the award, and during the beneficiaries of the award, they also filed a writ petition that was WPC 401. But my lord, subsequently, WPC 401 was withdrawn by them with liberty. Thereafter, my esteemed colleague came into the scene, and from their side, my lord, there is an interlocutory application, IA, seeking enforcement of the award in my writ petition. That is prayer number 1. Prayer number 2, in the alternative, what they are seeking is payment of 1/3 of the compensation. It is possibly under section 41, subsection 6 of the 2013 Act.
You represent NHPC. You want the
Yes,
question of the
yes.
award.
Writ petition is ours. And not alternatively, their third prayer is that expeditious hearing. On failure to get 1/3, possibly they will go for expeditious hearing. Now, my lord, so far as we are concerned, there were multiple interlocutory applications that were filed during the pendency of the writ petition. Now, some of these interlocutory applications have become infructuous. First of all, I will point out what those interlocutory applications are. Because while pointing out those interlocutory application, okay. Now, my lord, the first interlocutory application is, there are total 4 IAs. 4 IAs are there right now. 2 IAs will be closed. 2 will remain.
Which are those IAs?
The first IA is, my lord, 130 of 2022. I'll just point out, my lord, for what purpose we had filed this IA. My lord, this IA was filed because at that time Justice Robin Foucan had delivered a judgment in the Mihin Laling case, and there were certain observations in the judgment which had troubled NHPC. So we felt the judgment is incorrect, but since we were not a party to that very case, we had filed an interlocutory application seeking a larger range.
No, which are these applications first? One
The first is IA 130 of 2022.
Okay. Second.
Second is IA 214. 214 of 2022.
Okay.
These 2 IAs are required to be closed. Should I point out the purpose for which we had filed the IA, or not at all necessary? Since my lord, IAs are being
Once
closed.
you are desiring to close it.
Very
I'm
well.
going to
I need not burden my lord with the reasons. Very well. Now, my lord, I'll not come.
very small.
Naturally, my lord, my lord's hands are full. Too many irons in fire.
No. Small space.
My lord, that's not exactly the case, my lord, because 226 jurisdiction is very, very wide. And my lord carries 226 wherever my lord goes. So that's it. Now, my lord, 2 interlocutory applications are there. The first IA is, my lord.
I don't know why I always remember this movie called India.
Invisible, Mr.
No,
Invisible.
Yes. There is a very small puppet there. Every time it comes, it says Mugambo.
The burden is over. The 2 IAs at least. Very well. Now, my lord, the IAs which are now there, my lord, before your lordship, there are 2 IAs have remained. One is their IA, which is 73 of 2024. By their interlocutory application, they are seeking enforcement of the award number 1. Alternatively, 1/3 of the payment of compensation straight away, possibly relying on section 41, subsection 6 of the 2013 Act. And the third part is alternatively expeditious hearing. Our IAs that has remained pending because it is practically a counter blast to their IA. Now that the pressure is building upon us, we have filed an IA seeking stay on the award, full-fledged. Since there is no stay, that is why they are jumping. So stay on the award, pointing out the infirmities. Alternatively, my lord, we also want expeditious hearing.
That is which IA?
My lord, that is 85 of 2024.
For stay of the award.
Stay of the award, alternatively expeditious hearing. Now, my lord, so far as my lord expeditious hearing part is concerned, there is one development. It's only the last week, namely the last Friday. The last Friday, till now, state government was keeping quiet. Maybe the effect of the election. After a very, very long time, they were keeping quiet. After a very long time, Friday, my lord, the state government has filed affidavit in opposition. And apparently, my lord, my clients believe, NHPC believes,
Just a minute, this IA civil for stay of the award is IA civil.
85 of 2024.
Okay.
85 of 2024. There is IA 73 of 2024, enforcement of the award. Both. IA 73.
Enforcement of award is IA.
73 of 2024. Alternatively, 1/3 of the compensation to be paid. That is their case. Now, my lord, so far as expeditious hearing part is concerned, the latest development is the state government, which was keeping quiet till now, all of a sudden they woke up, maybe effect of election. Last Friday, they filed affidavit in opposition for the first time in the writ petition. We got the copy. Naturally, may not be sent. We informed the NHPC, and NHPC believes that some of the averments made in that very affidavit in opposition of the state government not. For that, I would require 2 weeks' time. Thereafter, matter can be taken up for hearing. We are ready for that. Now, my lord, I'll pass my IA because pressure is building up and considering the nature of their IA also. For that purpose, my lord, I will just point out the glaring infirmities in the award and as to why your lordship should not even allow their prayer for payment of 1/3 of the compensation under section 41 of section 6.
There's a question. You yourself say in your writ petition, there should be a fresh award.
I beg your pardon?
That there should be a fresh award. Your writ petition.
Is it agreed, my lord?
No, I'm saying something else. Our prayer is that there should be a fresh award passed. Correct?
There are glaring
No,
infirmities.
according to you, after the recalculation is done, would it go beyond 1/3 of the present award?
May I, my lord? I'm sorry, I couldn't follow, my lord.
Okay. Bad habit of jalebi pack. You see, what I'm trying to point out is that your prayer, one of your prayer in the writ petition, prayer number 2, is that there should be a fresh award passed. Now, I'm asking you is it the contention of the NHPC that if a fresh award is passed, it will be below 1/3 of the present award? Because if there is no, if the award is around 1/3, then what is the harm in making a direction of that?
I have got it. My lord, I'll give an answer like this. My answer would be like this. Though the prayer is that fresh award need to be passed, the prayer can always be modified. My lord, it is like if there are cancerous zones in the body. If the tumors in the body are removed after the surgery, if those tumors are removed, then the body may remain intact. But the point is the portion, how much portion of the body the tumor will take, to what extent the tumor has vitiated the entire body. So therefore, my lord, it will be difficult to answer that very particular question because what has happened here is there is a duplication in the compensation. Now, how there is a duplication in the compensation? Acquisition was under section 10, there is no difficulty about it, 1947 regulation. As the legal position is, you may carry out the acquisition under section 10 of the 1947 regulation, but for the purpose of determination of compensation alone, you follow the principles of 230. I have no difficulty with that also. But follow 230 that purely. Do not bring in RNR policy 2008 of the state of Arunachal Pradesh. What they did it, my lord, they have brought in the principles of compensation determination under the RNR policy of 2008, and by bringing that, my lord, they have applied the same over here also. The two components are there. First of all, 25% of the NPV, which they have calculated. NPV is, so far as the forest is concerned, forest land is concerned, that is how it is calculated. The second component, my lord, is 156,000 rupees. There is a calculation, 156,000, like that they have calculated. That is in addition to that. Thirdly, my lord, for the value of trees, 213 Act, my lord, doesn't provide for all that. So, my lord, how much of the component, once we remove that, what exactly will be the amount left? The calculation, somebody will have to do the calculation. We can't do the calculation, my lord. Certainly, the state government has to carry out the exercise. So far as we are concerned, my lord, we will be satisfied if the components that have come in by way of 2008 RNR policy, they are done away with, and only 2013 Act portion remains. We have no difficulty. That is the stand of the NHPC. Now, my lord,
So
there
if
is
quantified-
another aspect to it.
If quantified, how much would it come to?
It-
General
Not
calculation.
difficult. I haven't done that part of the calculation, my lord. Others are better, my lord, because under different heads they have brought in all this. So that is one part. Otherwise, my lord, we can go for expeditious hearing. Matter can be decided.
One second, I'm doubling your lordship, my lord. Friend.
Let him complete.
2024, this has been filed. And we have not given reply because he's asking for stay of the award. And 2020, this writ petition was filed.
No, let him
And
complete,
today-
because then my sequence would be
No,
over.
it's okay. But we need to give an objection if your lordship passes an award for stay of this award. Because if he's asking for
No,
stay
he's
of this.
first praying for allowing me to withdraw this to interlocutory application.
No, he's not in respect of ours,
No, he's arguing in two parts.
Yes.
First is that he's saying that there are two IAs,
Uh.
130 and 214, he wants to withdraw it. Since you made an objection on the last date, he's making his submissions first on that.
No, on that,
And
those are
then-
the instructions.
No, no, no.
Those IAs are closed.
That is
And
closed.
then second
is
party is arguing,
That is closed,
then second party,
That is closed. Nothing to do with it.
then second
Nothing to
part,
do with us.
no, then the second party is 85 and 73.
73.
That-
On that I am addressing my lord.
That's 85. 85 in respect of our particular case.
Yes.
Where he's seeking for stay of the award. But this has filed, they have filed on 18th of May. 24, this 24 they have filed it for stay of the award.
Okay,
The award is of 2018, which was committed in 2019.
so you want
All-
to file an
No,
affidavit.
there are two ways. One is that, my lord, the objection to be filed or for an expeditious hearing of
Yes,
this
very
matter.
well.
Either this of the two. Because all the affidavits are being filed.
Well,
It has been exchanged, all affidavits. So there is no question.
I'm willing for expeditious
What-
hearing.
that's-
But in the meantime, I will give a reply to that affidavit in the position of the state government. For that minimum 2 weeks time I require, my lord.
So if your lordships wants to hear this, then I have to file a reply.
Got it.
If it is agreed that the entire matter should be heard and disposed of. Because on 13th there is a matter, so it can be heard and disposed of. There is no
He's
problem.
wanting 2 weeks time
All, my lord.
to file affidavit.
With great,
I'm sorry.
He's wanting 2 weeks time to file affidavit.
naturally,
Agenda
because
against
it
your-
goes for waiting. And my lord, whole since Monday I am here. My lord, I have great respect for my esteemed colleague. You know, we all have our respective difficulties. But my lord, at least this much, the minimum.
You will require some time because it goes to
But
the
only the question here, miscase we have filed because for interim order. Interim order, whether we are entitled to get 1/3 of this total, the amount which has been 42 crores. This we calculated 142 crores, 1/3 is, it comes to 14 crores. Whether we are entitled, because they want this compensation which has been calculated, certain provision, they have USF plan, they have calculated. Even that for recalculation it goes. So even then whether we are entitled to get that 1/3.
That answers my
itself,
question. If it
that's-
is 14
that's-
crore, my lord,
Yes.
if those components are taken away, the 1/3 will be, my lord, much less than 14 crore. 1/3 will be much less than 14 crore if those components are taken away of RNR policy 2008.
No, that's why we wanted a clarity as
Sir,
to estimated amount.
calculations,
Because
my
you see,
lord,
because when you're
for lawyers-
that calculation,
my lord, yes.
they will ask them to do that calculation also. So that
Yes,
they are
then
aware-
I'll tell NHPC also, you do your calculation.
Yes, you do your part of
Because it's
calculation.
very difficult, my lord.
Well, otherwise, what happens is that
Because the state will not, interestingly, for the benefit of my esteemed colleague, at least he will have that idea. State government passed an order admitting it was wrong to bring in that very component of the RNR policy 2008. But my lord, against that very order of the state government, they filed a writ petition over here. Naturally, my lord, it was the prima
Those things
facie.
are okay, those things are okay, but we are concerned with because of the fact that once the land of somebody is taken away.
My lord, we have refused to take possession of the land from the very beginning. We have said we will not take the land. We don't want the land if this is the position. We have refused. We have not taken possession of the land, and my lord, land remains with the landowners.
After the award has been passed.
Maybe,
Everything has been
but
done.
my lord, it is between the state and the people. We have not taken the land. We have not taken the land. We said nothing doing. Let them use land for their own purpose. We don't want it. We can't be compared. And interestingly, my lord, there are clauses in my lord, RNR policy 2008 and also, my lord, in 2013 Act that if after taking possession of the land for a period of 5 years, you don't make a use of the land goes back to the original owner. Now, my lord, this very particular piece of land is needed for the purpose of resettlement of those people who will be displaced once the dam comes up. Now, my lord, so far as the main project is concerned, around 41 families are likely to be displaced when the main project comes up and reservoir is full. Then they will be displaced. For resettlement of those 40 families, this land has been acquired. Almost for next 20 years, possibly the dam will not be able, because we all know the experience of Subansiri. Here, may not in 5 years, if this land is not utilized, it will go back to the original owner under the scheme of the Act. We have pointed out while raising our objection that this is the condition. So, all of us have to put our heads together. State can't use NSPC as a milching cow.
Yes, Mr. Das, we agree to a date, given 2 weeks time and then fix a date.
Then it will come out only after vacation.
No, just choose a date.
That's why after vacation, when it reopens City Hall,
Choose a date. There's a calendar there.
In profession, Mr. Das is 2 years senior to me. But in age, he has admitted he is younger to me by 2 years. So, my lord, inside the courtroom, my lord, I will have his words. Subject to, my lord, my convenience. Outside, he will have to listen to me.
My lord is still with NSPC. He is no more interested in this DMP project. There is so many litigation filed by the
Because state creates such a situation.
When the PA, they are suffering because of this conduct of the.
Sir, it is your government.
NSPC at all does not require this land. It's okay.
Same party is in power in center as well as in the state.
Because these calculations, compensation are calculated under section 26 of the 13th Act or under general regulation. There is no provision in other. So therefore, award is issued either this other 2013 Act or under this procedural regulation. These
No, you can't take the stand because of the fact that your consistent stand all throughout is that for the purpose of acquisition, you are taking over under the 47 Act. Oh, sorry, Regulation Act. But the calculation is being made under the 2013 Act.
Yes.
Because if you otherwise take a water face, then it is the landowners will be affected. So that's why it was never your stand. And at least I did not find it. That your stand is that the acquisition compensation is not to be calculated under 2013 Act. This is something I did not find. Subject to correction because I probably read it.
In fact, I've taken all this ground. In fact, our policy 2008, those very portions, those very components they have taken into consideration for the purpose of calculating the compensation, it applies in the case of the forest land. Forest land, it applies. And they've applied those calculations, 25% NPV and 1,56,000.
No, that is one part. But the fact is whether the calculation is to be made under the 2013 Act or under the.
We have no difficulty. NSPC has agreed in principle. We will accept if only 2013 Act is applied. But we say don't bring in that case. RNR policy 2008. Keep it away. And because this land.
Because if that be the case, then it will be your department which has to take a stand, because you see, calculation is done by the deputy commissioner based on the state policy,
Yes,
correct?
based on state policy, yes.
Correct. So that therefore, if you are applying two parameters, I'm just accepting his statement. I've not gone into it. I'm just accepting his statement for the time being, that you're applying two standards and clubbing them together. The question is whether it is permissible. You see, what we are on, Mr. Contempt, what we are on is on the prayer made by Mr. Das, that they should be released 1/3. Correct? So it is in that aspect that we are making this exercise. Now, if there is a standard clarity between you and the NSPC, that this is the standard which is required to be applied. Number one, component of A, B, C, let us say, is to be applied. Or according to them, component A and B is required to be applied. Or according to the petitioner, component B and C is required to be applied. So therefore, if there are three parameters which would be applied, it is one part. And I can tell you, this is very important because of this, even if I start calculating 1/3 of what Mr. Das is demanding, we have to have a clarity in which component this 1/3 would constitute. So therefore, any delay on your part to have a clarity on that point, it affects the landowners. It doesn't affect Mr. Tiwari.
And you know, in that case, I will also take instruction from NHPC whether once this component is taken out from the entire gamut of calculation, that they're willing to pay 1/3. I'll ask them.
There should be a rough estimate. We don't say that.
The moment 14 crores figure is quoted, I'm 100% sure, my lord, but the 1/3 will be much less than 14 crores.
So
I'm 100% sure.
So Mr. Das.
So we have to see, let them come up, because if that is the case, then it may be not 42 crores, it may be 24 crores. Then we have to look into all of those aspects.
But less than
No, I
14
don't know,
crores.
I don't know. But my client is very sure that they doesn't want any compromise which they have made with other parties. I'll tell you a lot too. There are lot of lands which, lot of landowners were there, and they compromised. Lot of the landowners has compromised. Instead of those cabinet decision, what decision they have taken outside the court, they settle. Suppose there are some cases which I have been told, I have not gone through it, 1,600 crores. Some landowners settle with 640 crores. Why? You made a settlement outside the court, but initial amount was 1,600.
But Mr. Das, they
try to settle.
No, that's okay. But but you see, that has a legal basis. Because of the fact, even if you get a decree, still a decree can be compromised.
No, that I understand. Decree
My
will
lord,
be
that is
compromised.
there. In fact,
Decree
my
will
lord,
compromise. That to some extent it when
for the benefit of my,
they went to division bench also in one of the case.
my lord, for the benefit of my friend, Mr. Das,
No,
for the benefit.
No, it's
But
not.
I may aware your lordship also.
No, this is,
Developments on that.
no, this is not an argument on that point. What I'm trying to say is that,
We are not.
no, we are just trying to have a clarity. You see,
Seek an information, my lord, something which will be new to your lordship and it will benefit my friend. My lord would remember that very particular judgment my lord delivered in WPC 60. Lordship said, out of court settlement is permissible in law, it's a part of a public policy. What happened?
No, Mr. Tiwari, we're not hearing on merit right now.
No, but I'm just giving some information on that. It's interesting. Since the out of court settlement thing came up. So, my lord, after the judgment of your lordship, what happened was in a different matter, my lord Justice Tagia, sitting in a division bench, gave some cryptic observations in taking a contrary view. Against that, NSPC went to the Supreme Court. So, my lord, the entire issues before the Supreme Court matter has already been heard 4 or 5 times. All the sides are ready. Matter could not be concluded, and it keeps on coming, my lord, after every 2 weeks. So that is the state of affair over there. That matter is pending in Supreme Court.
We are dealing with about thousands of cases a day.
So like that.
We can't do anything. Because Mr. Kandu.
Yes.
But one second, just but they were a part of the committee. When 42 crores were passed, when it was resigned, they were also a part of the committee. Again, they have 42. I'll show it.
No, please.
I'll show it, my lord. They were a part of the committee. Now today they are coming up and they are saying all these decisions are wrong. Cabinet cannot take decision. How they have calculated? They were a part of it. I'll show it. How they were part of it. NSPC was part of it. They knew very well. When it was resigned, then subsequently again 42. That is why my learned friend's client had challenged that award of 42 crores has been challenged. Now today they are saying that okay, 42 crores cannot be. All the displays. Now what I have asked my client, get a photographs of it. How we are affected that way. Because rehabilitation, resettlement in respect of 142 hectares of land in a particular area. Now I told my client, get all photographs. How you are affected, how will be affected. This will get a photographs. These families, my lord, these always summers and all has resided in all water, all which I have been told.
No, I'm not, you see, the court is not disputing what you're saying. But
Well,
I'm on a different.
No, I have understood what your lordship
You
has.
see, the fact is that the discussion now being made is only with regard to your claim of 1/3. Now, you see, we are trying to understand from the submissions of Mr. Kamdok that if there is a very clear-cut explanation by the state as to what are the various facets of the calculation of compensation. Now, that's why I gave an example of A, B, and C. Let us say A is that 1947 Act, B is the RR, and the C is right to fair compensation. Now, which component they are applying? So, if there is a clarity on their part, it will be easier for us to settle your.
Right.
It would be easier for us to say that this, at least this amount must be released to you. But if there is a component, you see, Mr. Das, the problem we are now facing, not in this case, but in many cases in this this bench, is that under the Right to Fair Compensation Act, the right to appeal is available only to the displaced persons or whose lands are taken away. Therefore, a requiring authority does not have a right to appeal, which was earlier there under the Land Acquisition Act. Now, their only remedy is to come to court. Even assuming that they made they were a part of the committee, the exercise was made. But still,
We were
once,
not
no,
written
it's
signing.
okay. We'll take it from Mr. Das is saying we accept it for the time being.
All right.
Even then, a challenge can otherwise be made on the ground that these components were illegally incorporated. I was a member, but these were incorporated. We did not accept it. We did not understand at that time, and we accepted it. So they can reside by way of a writ petition. So that is one component. We are not saying that whether you are right or Mr. Tiwari is right at this moment. But we are trying to understand if the component, there is a clarity in the component, then it is easier for us to at least dispose of your application with some direction to make payment. But we must have some clarity. That's why we are asking, since Mr. Kamduk made that statement, that they are applying two parameters. That is why I asked him to give a clarity, because it is the government who is making that assessment first. They'll have to tell us that this is the component and this can be matter in dispute, and this is a matter which is, so far as the state is concerned, they are not going to compromise with that component. So we then understand the financial position, because you see, in a just lighter note to make the things lighter, let us say that there is an accident in the road. X, who is the eyewitness, he gives a description of that car, saying that this car after the accident, it is dent here, dent there, the lights have come out, the roof has fallen down. And there's another gentleman who saw the accident. He said that, okay, this car was of 2 lakh rupees. After this accident, it is not worth 20,000 rupees. So he gives a financial assessment of the car. If the car is of 2 lakh rupees and worth 20,000 now you imagine in your own mind what the shape and size of the car would be after the accident. So it's, for me, it's easier to understand the finance. So once they say that this is the component and they agree to that part, that okay, this can be a.
And if NHPC agrees for 1/3 payment, so then there would be no problem. There will be no contest of that. Because finally, NHPC certainly may take the land. The
No,
only
that
issue
is
is the main project.
Contest is in respect, what we file in this case in respect of that this 1/3 at least they should pay and the matter should be heard. That was the reason why I filed in this case.
That's why we are here.
That's why now the state has to, because it appears that this calculation was under 2013. But now the stand has been taken Of course, your lordship is right. They have to clarify which stance you have taken, A, B, C. Then calculation will be on the basis of that. My calculation will be on the
Now,
basis of that.
obviously, now by the passage of time, the, what you call the financial calculations may change. The market value of the land, the various irats standing.
There are no sale deed, nothing. Lordship knows this part. It is all artificial. All artificial. The government rates are there. Self-created. So that will not change much.
Can you agree to a date, both of you?
The date can.
2 weeks at least, I'll
But agree to a date, in principle, agree to a date.
let it be on 7. हाँ?
देखो तो
14 days निकाल दो यार.
14 नहीं होगा यार. It will be
No,
on
but 2 weeks
July.
I cannot.
July.
July, all right. Agreed. July में
22nd.
agreed. Agreed.
When?
22nd July.
22nd.
July.
July.
Okay.
Agreed. I have no difficulty.
Please, Mr. Das, Mr. Kamduk and Mr. Tiwari, please look at the order. If needs correction, please indicate. Please hear the order. If it requires modification, please indicate.
I want to ask. It's okay, madam. I'm not. 24th of
22nd of July, you said.
Second, please hear the order. If they need to make it. Mr. Kamduk, please repeat your stand in the context I forgot. Your statement which you are making.
I'll take it. Gender acquisition. The notification is given, other, the jailer. The calculation was made as per.
Under which act?
2013.
2013 Act.
Yes. And there is a cabinet decision. This is specifying the rates. And cabinet decision being the state policy.
Cabinet decision doesn't specify the rate.
It can be joined with the NSPC. And NSPC was also the part of all these discussions. Earlier there was an award that was rescinded again, rescinding order, that was recalled. So therefore that original award exists till today. This is 42 crores.
No, this is the this is under 2013 Act.
Yes.
Okay. There's no other component of any other act here.
That's it.
In this award of 42 crore,
Yes.
there is no component of.
So I will say that first this component, first of CA, first of PP and first of right and privilege of the tribal people. All are equal. There is this.
It has come from RNR policy 2008.
That is
the why is he not saying that? NPV. What is NPV? Net present value of what? Of forest.
all this has to be paid by the.
No.
Well,
Mr. Khandok, I am asking you for a reason. I am asking you the component is only of 2013 Act or any other law. I am specific in my query. Because otherwise, if I don't have clarity, I don't put in my order. Next, the same thing will happen. Mr. Das will have to go back, what you call, empty hands.
You know, it is on paper. I can show right now.
Please.
Lordship will have a look at the award itself.
No, please, because since I
Clear. I don't know why is he not saying that. And not their own order. The state government said, will not page 47 of the paper book, rate petition. I have marked it. These two clearly. And tree has been valued separately. See, I have marked it. Those two components are from the RNR policy 2008. Relief and
it's mentioned
rehabilitation.
here. It's mentioned here. Correct.
And tree has been valued separately. There is an order of the state government. Cabinet decision is different. It will not come on our way.
See. First, write two separate orders in IA 130 and IA 214. See, heard Mr. P.K. Tiwari, Leonard, Senior Counsel, assisted by
E. Pine. E. Pine, Your Lordship.
E. Pine, Leonard Counsel for the applicants. Also heard Mr. D. Kamrup, Leonard, Standing Counsel for the Land Management Department, representing the respondent number 1, and government advocate will be there. You, Ms. R. Basad and the government advocate appearing for respondent number 2. And also heard Mr. D. Das, Leonard Senior Counsel, assisted by Mr. R. B. Fukan, Leonard Counsel for the private respondents. Next, sir. Upon instructions, the Leonard Senior Counsel for the applicant seeks to withdraw this application on the ground that because of subsequent events, the matter has become infructuous. Full stop. Next, we said where, comma, having not been objected to, comma, stands allowed. This interlocutory application stands closed on withdrawal. Same order in two cases, 130 and 214. Then IA 73 of 2022. Mr. Das,
I'm sorry.
I'm now passing on already IA 73.
73.
Please hear it. If there is anything to be corrected or altered, we do it.
Yes.
This is now IA 73. Heard Mr. D. Das, Senior Counsel, assisted by Mr. R. P. Fukan, Counsel for the applicant. Also heard the same Mr. Kamdo, Ms. Basar for the government, and Mr. P.K. Tiwari, Leonard Counsel, assisted by Mr. So-and-so, Counsel for the NSPC. Next paragraph. The Leonard Standing Counsel for the land. No, you used to say this interlocutory application has been filed for enforcement of the award dated. What is the date?
What is it?
2018.
Communicated on 4/3/2000.
Communicated on
4/3/2019.
4/3/2019, by which the draft award amounting to rupees 40.06, 62, 641 was approved by the competent authority in the government. Next paragraph. In this the Learned Senior Counsel for the NSPC has submitted in this 73, the affidavits are exchanged. Mr. Tiwari, 73 affidavits are exchanged.
No, my lord. My esteemed colleague says that he may like to file in response to IA 73.
Yes.
You want to file a,
No, my lord, no, we have, 73, my lord, we have not filed our affidavit, now we'll file one. We'll file one.
the NSPC
Counter affidavit is filed in state.
Yes, we have not filed, we could not,
the NSPC would file an affidavit in opposition in the matter
in IA 73.
within 2 weeks. So for which he plays for 2 weeks time.
And also, my lord, we will file affidavit in opposition, affidavit in reply against the affidavit in opposition of the state government, which they filed last Friday.
In this 73.
Yes, in the main petition.
No. I am in one by one.
aye.
I'm not, multiplying things. 73. Okay.
We'll file here.
Next para. The next para. The senior counsel for the applicants has submitted that even if the objections of the NSPC is considered, at any rate, the quantum of compensation cannot be below 1/3 of the total award. Full stop. Next para. In an explanatory submission made by the learned standing counsel for the land management department, it primarily appears to the court that out of the calculated, there are 2 components under the court finds. You say the senior counsel for the NSPC submits that from this that out of this said award, 2 components being serial number 6 and 10 towards user right, as well as 25% of the net present value, are the components which have been borrowed from the, what is the full name of R&R policy?
Relief and rehabilitation policy.
Relief and rehabilitation policy, 2008. Of the
Rehabilitation and resettlement policy. Rehabilitation and resettlement
policy
2008.
of the government of Arunachal Pradesh, which otherwise cannot be imported for the purpose of calculating compensation under the right to fair compensations and transparency in and acquisition and what is it called? RR is
Rehabilitation.
Resettlement Act from 2013. Please check that name. Huh?
This, you can see the act itself. Have a look.
Just correct it. It's the name of the act. Okay. Full stop. He submitted that as per instructions provided to him, on exclusion of the said components, the quantum of compensation may drastically reduce. Full stop. Next paragraph. In view of the said issue which appears to have arisen in this matter, it would be in the fitness of the clarity. It will be fitness of things to have clarity that the authorities of the state, including the land management department and the deputy commissioner concerned, would apprise the court of the about the reasons for inclusion of components under different policy for calculating the compensation under the 2013 Act. Full stop. Next paragraph. Similarly, taking into account the various components of the award, comma, we also direct the NHPC Limited to provide us with their rough calculation of the they think would be next paragraph between the parties, comma, we direct the state respondents and the petitioner will instruct their learned counsel so that the instructions are produced before the court asking for an affidavit, because this is we are not asking this to be brought on affidavit.
Yes.
So in the binding, then
Otherwise,
this,
that will affect.
it will affect someone. Which will be for the perusal of the court. Yes.
Yes, it's okay.
Huh.
If necessary, we will also give a reply to their
Okay.
application.
First
They
off,
have filed for 3 of the
similar liberty is also given to the applicants to make their own calculation and provide the court with a extract of such calculation. First off, we make it clear that this information may not be filed by way of an affidavit, as ultimately it would be the call of the court to take a decision in the
Yeah,
matter.
that's an observation made. Only, but that will not affect the main
Well,
repetition.
you said there is a-
Yes.
Miss Mara, the agreed at the bar, comma, this is the matter on 22/7/24.
That day we may go for full-fledged hearing also, it's like, we may complete everything.
First off, it is made clear that that in the event, next para, it is made clear that in the event, for some reason, the petition cannot be heard, comma, the court would make an attempt to hear this interlocutory application. Mr. Das?
Yes.
We have made an observation in the order that if for some reason the hearing of the petition cannot be taken up, then we'll consider this application.
Yes, from this.
Correct?
Yes.
That's right. These are the, any other interlocutory applications pending? Any other interlocutory applications pending?
No.
Although you
these
said
two.
that you want to file affidavit somewhere.
So far as their application is concerned for stay, sorry, for enforcement of the award, there will file affidavit in opposition.
No, that is
But
okay.
in the
We have
main writ
raised that.
petition, the state government has filed affidavit in opposition
Okay.
last Friday.
Okay.
To that, we will give affidavit in reply.
In the writ petition. You say, writ petition, petition is by you.
Writ petition is by us.
So P.K. Tiwari for the petitioner, Mr. D. Kamdu, Ms. Basar, and then Mr. Das for private respondents. You say that on the prayer made by the senior counsel for the petitioner, time is granted to file affidavit in reply against the affidavit in opposition filed by the Land Management Department. Has agreed to both sides. So this writ petition is admitted for hearing.
Yes, it
Or
is.
is it still in admission stage?
Admission stage, no formal order is there.
Well, let it be not in the column of hearing, let it be in the column of
That should
admission.
be better. because-
Admission,
Well, in Arunachal, hearing is taken up.
no, even then there were
Here-
a number of cases. Final
Because-
disposal at the admission
No,
stage.
because you see, there's some difficulty, practical difficulty. In admission stage, normally, you're not coming at that prepared.
But here,
Because
hearing
your
is taken
lordship
up,
has passed an
both the
order.
sides are present.
Your lordship has passed order. Hearing, if somehow hearing doesn't place, then it will go down below in this case, that interim order which to be pressed.
Taken up.
Yeah, that's the important.
It will
Whoever,
take
I
up.
don't know.
So this can
Interesting.
work. We can put it for hearing so that we can expedite the hearing.
Right.
Otherwise.
But
the-
your lordship will have liberty if on that day somehow the
We've already
hearing.
passed an order.
Yes,
That's why I
yes,
told you.
Yes.
And in this petition say, in view of the nature of issues involved, the petition stands admitted for hearing by issuing rule returnable with without requiring any fresh steps to be taken. I released the matter for hearing on 22
July.
July 2024. First off, all sides are directed to exchange the pleadings by them.
Yes, right.
There any other application pending?
No.
No. You said something about one more.
No, total 4
85.
years were there.
No, but we not passed orders in all four. That's why I'm asking you.
73, 85 are pending. 85 is by them, and 73 is by them, 85 by us.
85 is what? I have not passed any order in 85.
85 interlocutory for stay of the award. Ours is stay, there is for enforcement of the award.
85. In 85, you want to file reply.
Yes.
And so we have to pass orders. No. Because Mr. Das, I'm passing on separately, otherwise everything is very confused. We don't know
Yes.
what is happening where.
Easier.
In 85, you say, here Mr. Das is the applicant. State Mr. Kamdo for the land management, Ms. Lasar for the state, and SPC Mr. Tiwari. You say, this interrogatory application has been by the NSPC Limited for stay of the award. This application, in this application, the private respondents, the senior counsel for the private respondents is from allowed 2 weeks time to file affidavit in opposition in the matter. First time. Pleadings be exchanged prior to the next date of listing. Next, release this matter on 22/8/2024.
22/7.
Seven. Okay, I'll just take a break and come back. The last order is okay, just check it up. That order.
I hope not, we are free.
Yeah.
My lord certainly is not. Certainly we are free, my lord. So.
No, I don't know, you see, the best part of the lawyer is that you can come without a warning, you can go without a permission. So
And
because
not-
I have nobody to tell you either to stay or to go.
And
No,
there is
one
more.
case is, what time the orders are being passed in our case? Orders are being passed
Yes,
in our
yes.
case. We are saying, definitely saying we are free.
My
Because
esteemed colleague has,
experience, what I am saying, this side, your lordship of the experience here also. Lot of difference is there.
my lord, he has many more things to
But,
say, which
but-
may not be disclosed in the open court.
Mr. Haidas, we wanted to hear you also. I have not heard your voice. You have anything to add? You want to say, add something to your
He
senior?
has to add. I thought that in one of the case I'll go out.
No, you
I'll
have
go
to.
down. Yeah.
Yes, we want to hear you.
Maybe some other day.
Huh?
Maybe some other day.
Maybe some other day, okay. But
My
these
lord, my
are-
writ petition is with your lordship. I'm more worried about that. That is the only copy I'm having.
No, because he's a boy, I've seen him small, so.
So then I understand that. I understand
So
that.
therefore, it is just lovely to find
Right.
young people taking up.
That's why, bar is a wonderful place. People
Yeah.
see each other growing.
They are the future.
That's it. That's the future.
But you do what I was told to do. Make it a habit of reading civil procedural code.
By senior Das.
Huh?
By super senior Das.
Super.
By super senior.
Yes.
That laid a foundation which is helping me now.
His paternal grandfather.
Had the blessings of both his paternal grandfather and his maternal grandfather. So it's good to see young people taking up. They are the future. We are fading away.
Your lordship is not fading away. Yeah, I am also fading away.
If he's fading away, my lord, I'm 2 years elder to him. He admits that. I'm 63, 61.
No, I don't know, but I'm saying of myself. I'm not saying about you. Here,
That's
all
why.
these few people, your assisting counsel, you, Mr. Das, Mr. Albi Fukan, Mr. Kamdo, their appearance is same for all these years I have been seeing them.
Lawyers are normally young till 70. Thereafter, my
But
lord,
your lordship, I will tell your lordship, 70, my grandfather, Joy Chaudhary, your lordship knows. 70, he retired. He retired because he told the case, what has happened in the court. He forgot one list of dates, doing one murder case, big murder case, he won that case. And his junior was Justice K.M. Lahiri, P.C. Kotoki, D.N. Chaudhary, all was junior. He forgot one list of dates. He came in the evening, he called my mother, then all my father was also called. And he said, from tomorrow onwards, I am not going to the court. Everyone said, why you are annoyed? You are annoyed with some judges. He said, no, because I think my memory is fading. I am 70 years old. Hence, from tomorrow onwards, I am not going to the court. And written to the income tax department. No discussion, no conference, I will not give any advice. And K.M. Lahiri, Justice K.M. Lahiri, everyone came running. D.N. Chaudhary came running, P.C. Kotoki came running. What has happened to this one? And that day, all the brief was entrusted to all the juniors. He never entrusted to his son, D.M. Chaudhary. And he said, I think he is not competent to handle this case. This is the person. It's rare we get.
Don't do that. You don't repeat that.
That's what I was thinking.
अच्छा, in the earlier red petition, give this one, the earlier red petition was the original petition.
May I please drop this? This is in connection to eviction notice issued by the Assistant Commissioner Mangyur project within the Papumpara district. Not the fact of the case is that if petitioner is occupation by farmers. So in 2003, petitioner has occupied one plot of land at Saking under the Mangyur circle. And since from there, petitioner stayed at that plot of land. And everything has been constructed over there, and their field, that's horticulture garden, everything is over there. So what happened, Lordship? Suddenly on 17 June 2020, one notice has been served by this respondent number 5, who is the Extraction Commissioner Mangyur, regarding that allegation of encroachment of police land at Mangyur. So on the basis of that, petitioner, Lordship, filed one reply on 12/10/2020 to annexure one lawsuit. So accordingly, petitioner has made the reply to the said eviction notice before the Extraction Commissioner Mangyur. After that, what happened? Again, surprisingly, on 21 November 2023, last year, lawsuit, again this Extra Assistant Commissioner Mangyur has again passed one impugned order regarding the eviction. So in this order is your honor hereby written that
Where is any document for your land allotment of yours? You also don't have a land allotment.
Lordship, that is place that is not particularly called to be as it is down. It's only a population of 300-400 person only reside here. That's not the big city, and that's not a big market line that like. It's usually punch. It comes under usually puncher. Puncher. It's almost village area like. So Lordship, what happened? To understand this spot, Lordship, page number 28. Lordship, page number 28. Annexure 6, page number 28. Lordship, this is my house and the area that my land. So now this respondent. Their state respondent, their Lordship, what happened? They are brought the JCB by engaging some private firm. They are now art cutting is going on. Lordship. See the page number 28, annexure 6. Lordship. So before that also, Lordship, what happened?
Yes, you have instructions in the matter. You have instructions in the matter.
No, my lord. This has been, this is come on motion, my lord, for the first time.
So Lordship, after 21st November 2000, that's impugn order, Lordship. I have again, Lordship, on 12th of the December 2023, I have made reply to the extra action commission regarding said impugn order. But Lordship, despite of that, Lordship,
Can you get information from the police by 2 o'clock about their land, if they have any land documents?
My lord, that impugn order is of 21/11/2023, my lord.
last year November.
The November, now today is 31st of May, my lord. The impugn order, what he's challenging.
So, Your Honor, before filing this writ, Your Honor, I have been called to the police station also. I am a Lordship farmer, Your Honor. See page number, Lordship.
You issue a notice within a
Yes.
week, 1 week. You produce this.
Now, my Lordship, my interim prayer is that, Lordship, now this respondent, Lordship, they engage some private that's firm. Now they are cutting my land, damaging my plantation and that property. See the page number.
No, your plantation and all, nothing is there.
So
Your
page number
plantation
48, Lordship,
nothing is
see,
there.
yes, it's rainy season, Lord. It's going to fall on my house also, Lordship. If this.
In a week, nothing will happen. In a week, nothing will happen. We are, today is Friday, we are fixing it on next Friday. You produce your, if there's a land allotment.
Lordship, in that connection, Lordship, we have filed one RTI also. That's so only RTI, we found only one rough sketch map in page number, Lordship, 33 of my page number 30. In 2020 also, Lordship, when they said that their land acquisition encroached, so accordingly, I have filed that one RTI before the ADC Sagali or Lordship. So we have furnished only this land sketch map copy, no allotment. Again, in 24 also, petitioner has filed the RTI before the concerned office, but this only part we have received, no land allotment. So I have enclosed my RTI, that's front page document also, page number 31.
We won't understand that because you don't give your RTI application. What did you want? That application you are withholding. Have you produced the RTI application? No. You are showing us a reply. We don't understand what the reply is unless we have the question. Heard Mr. T. Topu, learned counsel for the petitioner, as well as Mr. N. Ratan, learned additional advocate general for the state, appearing for all the respondents.
From
No,
1 to 4.
respondent number
1 to
1
4.
to
1 to 4.
1 to 4. The petitioner claims to be in possession of a land over which the police administration are carrying out land clearing activity Where is the order under challenge? Which page?
Impugn order.
Impugn orders, election number 2, page number 22 also.
Page 22.
Page 22. Annexure 2, page 22.
Stop. In this regard, it is projected that by the impugn order dated 21/11/2023, the extra assistant commissioner, Papumpara district, had expressed dismay about the encroachment of the police outpost land at Mengio, MENGIO, with some public. And accordingly, all the encroachers were directed to vacate the land within 1 month, failing which necessary action shall be initiated against the encroachers. And the officer in charge of Sagali SAGA police station was directed to execute the order. First of all, the petitioner claims that the police administration through respondent number, which that I have already given, not required. I have already given that, not required last time. Next para. The learned counsel for the petitioner has submitted that the petitioners the petitioner is occupying the said land for last about how many years?
21 years.
21 years. And that according to his instructions, comma, there's no land allotment document in favor of the police outpost. Next para. In view of the nature of grievance raised in this petition, comma, the court is inclined to issue a notice, including notice on the prayer for interim relief, returnable on 7/6/2024. Stop. The learned additional advocate general shall obtain instructions as to whether there is any land allotment in favor of the police public district administration in respect of the land which the petitioner claims to be occupied by him. Next paragraph, the learned additional advocate general shall also obtain instructions as to whether the impugn order dated 21/11/2023 was issued after after initiation of a enforcement proceedings. Next paragraph, the learned additional advocate general shall send a downloaded copy of this order to the concerned respondents to elicit information. Next paragraph. The next paragraph, till the next returnable date, the police administration under the Sagali police station shall not enforce the order under memo number capital MGO. This page 22, huh? Number so and so dated 21/11/2023. Next para, the petitioner shall furnish a certified copy of this order before the officer in charge, Sagadi Police Station, to bring the order to the notice of the said authority.
My lord, may observe, in respect to his, home, my lord, house, my lord.
Huh?
In respect of his house, my lord, no eviction in respect of his house.
So no eviction of the petitioner from his house.
Yes, my lord, otherwise he will again stop the entire thing, my lord.
Okay.
Lots of items of similar items,
Same land,
similar,
same area,
Same area.
same area, sir. Same issue.
same order.
Item number 14.
The impugn order is also same. The impugn order is also same.
Same,
Number is also same.
same. If you order everything is same.
Yes.
Your Honor, in this matter, I have to file a rejoinder, but
Rejoinder.
yet I'm not filed because my senior counsel is out of stations.
Okay.
So give me some time to file.
Both sides are represented on the prayer made by learned counsel for the petitioner. List after 2 weeks so as to enable her to file affidavit in reply in the matter.
Item number 15.
Yeah, please, Lords.
Oh, this is contempt matter. This is contempt matter, madam. Now, let's kindly see order passed by this honorable court on 10th of April 2024, madam. Previous time has been given to the alleged contender to take steps for compliance of the.
Mr. Tapin, you appeared for the respondent?
Yes,
Yes. What
there was a
happened?
financial bid was, has been already opened.
Huh?
Financial bid has been already opened,
Hmm.
the petitioner, and it has been submitted for final decisions by the government lawsuit. So since lawsuit, government is here.
What is the order? What is the order of this court?
Yes, madam. Order of this court is.
To open the financial bid of the petitioner and to reach to a logical conclusion lawsuit.
Okay. This was the order of 8/8/23.
Madam,
What is your affidavit? What you are saying?
Page 11 is, madam.
In your affidavit, what you said, which page?
Lawsuit, in my affidavit, since appeal was lawsuit filed against this order, and which is still pending before the Honorable Division Bench lawsuit. So since the appeal was pending, therefore lawsuit, the opinion of the law department was taken, what to be done. So opinion was that though there is no bar, because there is no stay from the Honorable Division Bench. Then, but even then, since the matter is sub judice, just hold on. So that was opinion. Therefore, it was just.
Okay. When is the writ appeal filed?
If
Interim order was passed, no.
It's my lord, the impugn order is at page 11 of my contempt petition, not page 11. madam. It was passed on, my lord.
No, then there is no contempt.
8/8/2020.
Then we'll have to close it. This contempt has to be closed. You see, the writ appellate order is that the order of the single judge would be subject to final outcome. So they can't implement the order. If they implement the order, then nothing would remain in the writ petition, the writ appeal.
Yes, madam. It was, but my lord, before that, my lord, there is my lord, observation made by the Honorable Division Bench, my lord.
No, once they file the appeal.
My lord,
you can't say that
my
they are
lord,
willful-
my lord,
willful
may kindly appreciate, my lord. This writ appeal was filed, not filed by the state, my lord. It was filed by, my lord, some, my lord, the firm, my lord, who was disqualified in my technical bid, my lord.
Whoever is filed,
And my lord, they are not, my lord, they are, my
no,
lord, if-
whoever is filed,
yes, my lord.
but we see in the order that the observation is that the order will be subject to final outcome.
Yes, my lord. Thereafter,
They can't
yes,
do
my lord.
anything.
I agree, my lord. Thereafter, my lord, there is subsequent event has been happened, my lord. So, my lord, this writ appeal has not been pursuing by the petitioner, my lord. Their advocate, my lord. They have been withdrawn their wakalat nama, authority, my lord. There is subsequent two orders, my lord.
We can't say about all those things in a contempt.
Yes, my lord.
In a contempt, the inquiry cannot be beyond a particular sphere.
My lord, actually, my lord, on 10th of, my lord, April 2024, my lord, this issue has been duly deliberated before this honorable court, my lord. And I have also placed one judgment, my lord. When it is said, my lord, tendency of writ appeal, my lord, without any stay, my lord, will not bar to proceed with the contempt petition. It's a small judgment. And this is what's being discussed, my lord. That's why, my lord, on 10th of April, my lord, this order has been filed. They have been given 2-3 weeks time to take a step to comply with the order passed by this honorable court.
Let me search Lampur and counsel for the petitioner, as well as Mr. S. Tapin and counsel for the respondents. Next, brother. Alleging non-compliance of this, of the order of this court dated 8/8/2023, passed in WPC 255 within bracket AP bracket close public 2023, the present contempt petition has been filed under Article 215 of the Constitution of India, read with sections 11 and 12 of the Contempt of Courts Act, 1971. Next one. The case of the petitioner is that this court, by the order under reference, had issued the following direction. It's page 14. Blue pencil mark. Next, brother. Next, brother. Copy of this, the certificate copy of the said order was served on the secretary from Women and Child Development Department on 10/8/2023. However, within a reasonable time thereof, the order to the court was not complied with. Accordingly, the petitioner served another dated 1/11/2023 to the Director, Women and Child Development Department, to put the said authority to notice that if the financial bid of the petitioner is not opened, within a period of 7 days, comma, we shall be constrained to file a contempt petition. Next one. The notice issued by the court having been served on the respondents. The respondents have appeared before this court and they have filed their affidavit in opposition dated on 2/2/2024. Whereby it is projected that you have opened the financial bid.
Yes.
So where did you say that?
Lordship, it was on after filing of the affidavit, Lordship, on 23rd April, Lordship.
Oh, sorry, okay.
The copy is with me, Lordship.
Okay. When it is stated that the respondent authorities had decided to open the financial bid of the petitioner, and the date of 15/12/2023 was fixed for opening of the e-bids. However, in the meanwhile, the earnest money deposit had already been returned to the petitioner, which was required before the financial bid is opened. Accordingly, the petitioner was sent a letter dated 15/12/2023 for submission of the EMD. And accordingly, the petitioner by a letter dated 15/12/2023 submitted his EMD by way of a demand draft. Full stop. Next paragraph. It is further projected that in the intervening period, the respondent department, the department of the respondents had received a copy of the writ appeal number 35 AP of 2023 and IA within bracket C number 189 and 192 within bracket AP of 2023 filed by one Mrs. POPU Enterprises, challenging the order dated eight 2023, passed by this court in writ appeal number 35 AP of 2023. No, sorry, petition number so and so, passed in WPC on 255 of 2023. And accordingly, the petitioners have taken a view of the law and judicial department in the matter of opening of financial bid. And they were advised that since there was no specific order from the appellate court regarding the stay of the operation of the order passed by the Granite Single Judge, there was no bar preventing the department from opening the financial bid, however, the department may await till the writ appeal is decided by the appellate court. Accordingly, the financial bid of the petitioner could not be opened. Where's the writ appellate order? Next, the petitioner by filing an affidavit in reply has produced a copy of order dated 4/3/2024, passed by the division bench of this court in WA 35 of 2023, wherein this court had issued the following direction. This pink flag, last, even last, pink flag, pencil mark. Next paragraph. We find that the division bench of this court took note of the urgency involved in the matter of supply of medicines. And it was clarified that there was no bar for the authorities to procure supplies from the petitioner in terms of the order passed by the learned single judge. But it was also provided that such order would be subject to final outcome of the writ appeal. That's right. In view of the said factual position and considering the submission made by the learned counsel for the respondents, the court is of the considered opinion that when the orders passed by the learned single judge is made subject to final outcome of the writ appeal, the interpretation made by the petitioners to keep on hold the opening of the financial bid cannot be said to be a deliberate and willful disobedience or violation of the order of this court. Dated 8/8/2023. This one. Therefore, what is the constitutional opinion that this is not a case where. Next paragraph. At this stage, the learned counsel for the respondents has produced a copy of proceedings of financial bid evaluation carried out on 23/4/2024 and the financial bid of the petitioner was opened. And we find that there is a note appended thereto that the financial bid was opened and the final recommendation shall be made after evaluation of the rates of the medicines quoted by the petitioner with the market rate of the medicine in compliance with the judgment of this court dated 8/8/2023 and final outcome in WA 35 AP of 2023, IA number 189 and 192 within bracket AP of 2023. Full stop. Next one. Therefore, next one. The copy of the said proceedings is retained as a part of the record. Next one. In view of the fact that though belatedly the financial bid of the petitioner has been opened, and we find that the said order and the respondents have taken note of the orders passed in WA 35 of 2023. So we find that. Okay, so willful and we again reiterate that no case of willful and deliberate disobedience of the order of the court has been made out. So according to this, contempt petition stands to